Lisa from Been There, Got Out. Sorry, we're starting a few minutes late. I just got off meeting today's guest. Her name is Michele Locke, and she is an attorney, but she is also a former domestic violence judge. And so I thought, oh, perfect person. Here she is to talk about the issues that all of you, let's see if we did the same thing at the same time. But anyway, today we're going to be talking about how to create a compelling case in family court, among other things. And thank you, Michele, for coming. But before you even introduce yourself, can you talk about the question that I just got that we get all the time is like, what do you do if your judge is corrupt?
Oh, that's always a question that's a terrible one to answer, simply because my findings in court were typically we don't have the corrupt judges. That being said, if you truly believe they're corrupt, and there's most judges have a judicial authority that they're responsible and have to answer to. And so if you truly believe the judge is corrupt, then you file a complaint with the respective judicial commission that covers them.
Yeah, yeah. I mean, we find that too. I think a lot of times there's a sense of helplessness with people where they think, well, I'm never going to win, and the judge is corrupt, and it's biased and all that, and my attorney's friends with the judge. And I know in my own decade in the legal system, I was worried about not corruption, but the friendliness between various judges and my ex-attorney. And, we have attorney friends, and one very good attorney friend said, Lisa, we play volleyball together. Judges care about their legacy. They're not going to risk their whole reputation for some friend that's a lawyer. So judges want to make sure that their cases are done properly. They don't want them to be appealed. So don't worry about it and stop talking about corruptions because it's really not a huge issue. Great.
I completely agree. As a general rule, I find that the judges really do want to do a good job, really care about doing the right job, and it's a tough job that I really don't want it. Like I had it before; it was great while I did it, but honestly, I don't know that I'd go do it again. It's a
Yeah.
tough job.
Yeah. Yeah. So tell us a little bit about your background.
So I've been a licensed attorney now for 20, I'm in my 23rd year, which I still can't believe. It makes me, I used to be the young attorney always, but now I'm the one they come to for advice. I'm like, well, why are you coming to me? But unfortunately, I have all the experience.
Uh-huh.
I was out in far west Texas when I started my practice. And early on, I became a judge at age 31. I was a municipal court judge for a period of time in West Texas. And then from there, I became an associate family court judge over a protective order court. So it handled the majority, probably 90% of the protective orders for the county in which I resided in. And then out of that, all of the family law cases that came out of those protective orders. And then in addition to that, I handled CPS for a period of time as well. So it was the ugly of the ugly for cases.
Yeah. How did you deal with something we call compassion fatigue, where you every day you're hearing these stories and stories about these terrible situations? How do you manage
I
that?
left the bench. Because I left the bench because at some point you do get desensitized to the he hit me, he punched me, he choked me. You do get desensitized to that. On the kids stuff, the CPS in particular, you're still pretty horrified because the stuff that gets done to little children is just unimaginable. But it is a challenge at times, and so you have to be diligent in making sure that as a judge you are still remembering that these are tragic and horrific for the people that go through them. And just because we see it every day on the bench doesn't mean it's not horrific for each and every individual that's coming before you that went through it.
Yeah, yeah. So let's talk about how court is basically a second battlefield. Absolutely with your experience with domestic violence that professionally, that coming out of one toxic relationship, you enter a whole new difficult one when you walk into those court doors.
Oh,
How do you see court as, to me, re-traumatizing victims?
so court is truthfully the last place you probably want to be. Um, for decisions regarding your family, because there is never enough time to get the entire story out so that the judge can fully understand. I can tell you in court here in Central Texas, we have 5 hours of testimony a day. That's it. Y'all, that is not much time. It's very condensed, it's very to the point. And so the points that you may want to get out, you're never going to be able to get out because there's just simply not the time. So the judges you're required when you go into court to hit the highlight. It's the highlight reel for the court, so the court can make a decision. And you've got someone that has never met your family, doesn't know your family, making decisions that impact the rest of your life,
Mhm.
because it impacts how often you see your kids. It affects who pays what money. It affects every aspect. And so if you can get a resolution without going to court, then that's a great thing. But otherwise, if you're forced to go to court, and a lot of times with certain personality disorders, there is no hope of settling before. And so you do get re-traumatized because you have to sit on that witness stand in that same courtroom with a person that has already traumatized you throughout the marriage and recount all of that for the court in a public forum that anyone can get the transcript to. So does it re-traumatize? Absolutely. It's family law is a black and white statutory system that is designed to resolve problems for cases that are not black and white. And that really is where the problem lays.
Yeah, yeah. I mean, so much of what you said, I started thinking about how there is such limited time. And when Chris and I work with our clients, we say, when we work on presentation, we say it's like you're paying $7 million for a 30-second Super Bowl commercial.
Exactly
You
what it
need
is.
to be in there. We teach something called front loading, where it's like, I used to be a high school English teacher, and we did the hamburger essay, 5 paragraphs. So the intro is like your opening, 1 paragraph long. Your Honor, here's what I want. Here's why I think I'm entitled to it based on your case and the history and the timeline and case law. And that's it.
That's it.
And I used to write these beautiful long speeches back in my early days of representing myself. And the judge would be like, Miss Johnson, what do you need?
Right.
What do you need? I'd be
Wait,
like,
let's get to the point. Tell me what you want. I mean, that's what we have to do, and it's difficult for clients because they're like, but there's so much
I
more, because
know.
clients want their pound of flesh for being wronged, and I got to tell you, that's never going to happen in court. You're
Right.
never going to get the pound of flesh that you believe you deserve. It just it's just not how it's designed to work.
Right. This is not a Few Good Men movie.
No, I wish it was. I wish I had some Tom Cruise in there, like in my daily life. That'd be okay. But unfortunately, it's not how it works. You don't get the aha clarity moment, and the person on the stand admits that they were horrible to you for 20 years and they're sorry. Y'all, you're not going to get that closure.
Right. Or the surprise evidence that just suddenly comes out.
Right. The pot of gold, we call it, because there's always a search for the pot of gold. You never find the pot of gold. It's usually not there. And sometimes it is, but it's usually not what you think it's going to be.
Yeah. And more things with court trauma isn't just going in and having to recount the story, but all the surrounding things. The looking at discovery, going through all of the history which you tried to push aside, and learning more things that you didn't realize, and then getting the emails. I know for me, everything that came from the court, even when it was great news, just seeing that in my inbox, like I couldn't breathe. And even as I read great orders, I still couldn't breathe. And I have to read it a couple times and have someone else read it to me because I was so scared all the time. Because, like you said, somebody else has the power to make these significant decisions about your life, your kids' lives, and future generations. They are affected by your trauma.
It is.
So it carries down
Absolutely.
deeply. Yeah. And one of the things that we try to do with our clients is everything we can to keep them out of family court, especially when it comes to parenting plans and schedule, because we've heard that judges have notebooks of templated parenting plans that don't have the details that matter to your family.
That's correct.
Certain religions and holidays they're not going to pay attention to, your rituals, your traditions. None of that's going to make it into a court-ordered parenting plan. And that's why it's so important, even if you go to court, to be very prepared with at least having something, I would guess, to present to say, could you at least look at what I tried to negotiate with my ex that covers all of the bases that you would normally do, rather than just leaving it up to this notebook template plan.
And we do it, and the judges are, at least in Texas, there's a presumption of what possession schedules in the children's best interest. And you've got some judges that that's what they order every single time. They're not going to deviate from that standard requirement in the law because they don't believe the presumption's been rebutted. And so, and that schedule is not a good schedule. I mean, at least in Texas, it's 30 days in the summer if you all live within 100 miles, and then it's 42 days if you live over 100 miles. I gotta tell you, I was a kid that lived through those 30 days in the summer with my father when my parents got divorced, and that's horrific for children. Like, whoever thought that was a good idea either hasn't been divorced or didn't have kids or both. Because that 30 days in the summer, and it's terrible for the kids. It's not just the parents, it's terrible for the kids.
Mm-hmm.
And when you go to court, the courts, again, this I can tell you in Texas, they have to follow that unless you prove that it's not in the best interest and to deviate from it to another schedule. But you're right. Like, you want to front load. You want to say, Judge, this is exactly what I want, and that includes additional holidays. Sometimes the courts will order it. Sometimes the courts will say we don't have the authority to. It just, yeah. You don't want to leave your life and your kids' life and your time with your children in a judge's hands unless you have no other choice. And I go back to, there are some personality disorders that you're not going to have a choice, and that's just who you married or who you're in a fight with. And I also like to remind people, because I think somehow when you get in a divorce that the person you're divorcing is going to change and somehow be reasonable through the divorce. If they weren't reasonable in the marriage, they're not going to be reasonable on the divorce. Like, they're not changing who they are, because I've got clients that are like, well, I just don't understand why he or she won't agree. I'm like, well, you really expected them to change because they were agreeable beforehand? There's a reason why you're getting divorced.
Yeah, you're reminding me of something that my old divorce attorney's paralegal told me. She said the power dynamic explodes 10 times during a divorce than what happened in the marriage. So if you think it was bad then, wait till you go through divorce with someone like that.
Right. 'Cause they're no longer your buddy. They're no longer your friend. They're no longer your ally. They are there to take what they want and leave you with very little. Some of them are fair, but those ones usually resolve. They don't end up in court. The ones in court are, and unfortunately, I'm in court a fair amount. And I think it's gotten worse since COVID, unfortunately.
Yeah. Yeah. And I also like how you talked about, and I think we should make this clear, judges have to follow the law of their states or country. So people get very angry with judges making certain decisions, but they have to follow the law. They can't just go rogue and say, well, I feel bad for your situation, right?
Right. And that's why encouraging people to settle, like in mediation or some kind of collaborative process, is so much better, because you can do the things and agree to the things that the judge cannot order.
Mm-hmm.
And that's one of the beauties of reaching an agreement before you get to court, because the court's hands are tied by the law. And that really is part of the problem, because you've got a statutory black and white, here's what the law says, to a emotionally charged, socially impactful case, because it is. It's, I mean, how many kids have issues because their other one parent left and didn't come back, or they got very little visitation,
Mm-hmm.
or one parent was bitter because they lost all the majority of the money. And then the biggest thing that I tell people is there are things said in court that you cannot come back from.
Mm-hmm. Tell us a couple of things like that.
Um, I've seen personal insults. I think one of them was her thighs had more hail damage in Kansas City. Completely inappropriate to say, completely mean spirited and
Mm-hmm.
ugly and designed to hurt. And I guarantee you that woman will never forget it.
Yeah.
Because I never
Yeah.
forgot it. Like, if it stuck with me and it was horrific to me, imagine what it was to the victim. But there's stuff said in court where they'll say, oh, she or he is crazy. And they'll say mean, ugly things because they're accusing them of doing stuff. And
Mm-hmm.
you can't, that going to court does not help co parenting.
Yeah. Yeah. I always think about the transcripts. That becomes part of the record.
It does. And then their public record, like the
Mm-hmm.
evidence you put in is public evidence. I mean, any person can walk into a courtroom and sit down and watch. Like when we had the days of YouTube, our hearings being on YouTube, you had people all over the world turning into hearings. And so when you go to court, potentially your kids down the road can come back and get the transcript.
Hmm.
That
Plural.
can be a problem.
Yeah, yeah, and that's one of the reasons to try to settle outside of court and to have leverage over certain personalities, like people who have a personality disorder who often care so much about money and appearances. And if they have a reputation with their job, if you're going to court, all that's going to be right out there.
The biggest advice that I will try to give clients is that when you are in litigation, divorce litigation, and it's going ugly, you have to learn how to manipulate. You have to learn how to not engage on every single point. You have to pick your battles carefully, and you also have to remember that everything you put in writing is Exhibit A.
Yeah. So we teach, I call it strategic communication with our clients more than anything else. We have a course that's called How to Communicate with Your Ex Without Destroying Your Case or Losing Your Mind. And I was a high school English teacher. My background is as a writer, and I feel like we do so much that AI is a tool. It cannot create amazing evidence for you. And I
No.
think the court, we always say, one of the best exhibits you can give is your communication in writing with your ex, because one of the custody factors is the level of cooperation
Yep.
or lack thereof. So we encourage our clients to present. We always say you're writing to your ex, but you're writing for that invisible audience. So you cannot afford to pop off, we call it. And so one of our perks for our clients is we put them on what's called the permission slip plan, because I used to be a high school English teacher, where I'll say, you send us a draft of what you think you want to say, and then we will proofread and edit it for you, because we want you to have clean hands and the record to be clean. And we're very, very conscious of who's going to be looking, and you can't take it back. And then if my partner were here, he's got a slide of a beagle with a big muzzle over it. And we're like, that has to be you. And not just in your writing, but your face in court as well, which is so hard for me, especially as a New Yorker, because I
Oh,
roll my eyes. Oh, it was so hard to control my face, especially on Zoom during COVID. And I would forget, and the judge would be like, Miss Johnson, stop making that.
I'm sorry. Listen, I've been doing this and in the courtroom for 23 years, and I still make faces that I know I shouldn't make. 'Cause I hear some testimony, like I was in court. Oh, this was last year, and some of the evidence that came in was that this woman needed her boyfriend at the time to blow marijuana smoke in her ear to solve her anxiety. Like when she's having a panic attack, that's how he would stop the panic attack. And I know my face when that was said. It, I'm still dumbfounded that that was actually a comment made in court.
Yeah.
But I know I didn't keep a straight face. And I tell, so you tell your clients that. I tell them the BIFF method, which is
Mhm.
brief, informative, firm, and friendly. And then I always tell my clients, what would Michele do? Is Michele going to get really angry at me if I send this correspondence in this way? And if the answer is my divorce attorney is not going to like this correspondence, then don't send it.
I know. Easier said than done.
And never
Easy.
send when angry.
I know. Again, easier said than done.
I know. I know. And you can't engage in it all. Like sometimes your response is just, okay,
Yeah.
that's it. Like don't engage, because the ones with personality disorders that you're going to end up in litigation with down the road again want you to engage. They want that ability to manipulate and control once they get you to engage. And it really is an art form to learn how to communicate properly
Mhm.
for future litigation.
Right.
It is an absolute art form.
Yep. We say the same exact thing. Yeah. It is really, really hard. And I think a lot of it is learning impulse control and learning to pause. We like the Biff Meth. I've interviewed Bill Eddy. I love him. I think his stuff is amazing. Ours is a little bit different because it's not just the general tone. It's like, say, a fact and then a certain response and then a universal agreement and then a thing about cooperation. But even that, it has to be customized to the situation. So it's not like, here, just do this and it's going to be fine. These are humans that we're talking about with emotions, but it's really hard. And we also note that someone with a personality disorder doesn't care if it's your positive or negative attention. They prefer
Doesn't.
your negative attention because they see if they get under your skin. And so a lot of our reining in with our clients is like they'll send us a draft and we'll be like, here, we're going to take that and we're going to put it in our little pile of things that will never be sent to your ex. And we're going to make a book out of that one day. But for now, that's going to stay here. Now we're going to clean it up and then you're going to get it back and you're going to learn how to do it yourself.
Yep.
So, and
Because
then
they
you're going to get
do,
empowered again.
you have to train your brain to think differently when you are communicating for purposes of your kids in particular.
Mhm.
And well, not always, but would usually recommend that the parties use, especially if it's high conflict, our family wizard,
Mhm.
so that I can't tell you how many trials I've had where the trial's an our family wizard trial, where it's
Yeah.
2,000 messages that get introduced in trial to show the dynamic between the parties. And there's some stuff that's said in OFW that I'm just like, wow. And they have a tone meter too. So
Mhm.
if you're still violating the tone meter on OFW, you're not communicating appropriately. And I will tell you, I've cases have been won and lost based on what is an OFW.
Yeah. Someone just wrote a comment that I want to note. My ex is using the fact that I did gray rock method or minimal engagement beyond dates times facts as alienation, and I think that has to do also with communication as an art form because you can't communicate too little. Like some things, just the one word or no answer, but other things have to be done very tactically. What do you think, Michelle?
Yeah, in this type of scenario, it's the same thing why the going to court's a bad thing. One size does not fit all. You have to adapt, you have to modify. Um, I always like to think it's like, what information, if you were the parent receiving it, would you like to know? And so if it's information that you'd like to know, then that's the information you share, but you don't share it in a commentary manner. You just make it here, like doctor's appointments. Here was the doctor. We met with the doctor. This was what they was diagnosed with. Here's the prescription information, and then tell them you can check on the portal because most doctor's offices have portals now, and just say refer to the portal if you have any other questions. But sometimes you've got to give more information than just minimal engagement. Now, I understand why people do minimal engagement. It's because dealing with someone who can be that difficult, it is for your sanity to keep it minimal. Like, because it's, if you were from an abusive relationship and you don't keep it minimal, then you're engaging, and you're re-traumatizing yourself. But on the other hand, if you're going to end up back in court, you got to communicate more. Doesn't have to be on all issues, but on issues that are likely like medical, major educational issues, like your kids, show me mine, I'll show you yours on the playground in kindergarten. Like, you're probably gonna want to share more information than just, hey, call
Mhm.
the school.
Right, 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 right. What do you think about answering the question or asking why in communicating with your ex?
No.
Right?
You're inviting a disagreement. No, you don't ask why. You don't, I mean, yeah, don't ask why. If you're asking why, you need to change your communication.
Right, exactly. And that's so important to note. Okay, let's shift a little. Let's talk about how to protect your peace without losing your
Ooh,
mind. So, what are some tips that people can do properly when they are either, well, other than trying to stay out of family court? Let's say you are in family court, it's unavoidable. What can people do pre and during?
so I'm going to talk about it from the mental health, taking care of yourself perspective, because I think that is the most important, because you can't get to the end of that tunnel unless you protect your mental health.
Yeah.
And so a lot of my clients will be concerned about, hey, I don't want to take any medication, but I'm depressed. And I got to tell you, a court is not going to fault you or take your kids away because during a divorce you went and sought mental health treatment and got put on an antidepressant.
Pause
Because
because people need to really pay attention to that because many of our clients are terrified. I'm on anxiety medication. My ex is saying that I'm an unfit parent and they're going to use it against me in court. And we tell
yeah,
them too, it
it
doesn't
doesn't
matter. It's
matter.
okay. Like most of the world, most of our country at least, is on antidepressants, especially during and post COVID.
Correct. And so for me, and I tell them, no, go see a therapist. If you need medication, I mean, I'm not a doctor, so I can't tell them whether they need it or not. I said, but if your doctor tells you you need it, we can manage that in court, and that's not going to be an issue. What is more of an issue is if you don't
Yeah.
treat it. and then you have some kind of mental health breakdown, hospitalization as a result, going to the ER because you're having a panic attack and collapsing,
Mhm.
there's actually more consequence for that than if you go the other route and actually take care of yourself. And so I tell clients, you have to protect your mental health. My business coach actually taught me, and I love this, is whenever you're like, it's just too much, just free form write everything. And don't stop until you are done getting it all off your chest. And it could be 8 pages, it could be 10 pages, it could be 1 page. And it doesn't matter. Just keep writing everything that comes out of your brain to your pen. And then sit on it for a minute and then go burn it. It's amazing how much, sounds silly, but how much that energy release really helps.
No, I totally get it. I mean, I've kept journals since I was 12. I think all of my writing kept me uh, healthy as much as possible through it. And it's just, you need that release. And people, I think, in their communication think, well, I have to get it perfect. That's why we say when you're on the permission slip plan, you can send us a draft of what you think you would like to say. We can fix it, and then you can send what you know you should say, but you need to get it out. And if you can't do it yourself in a journal, just send it to us and we'll read it. We'll probably laugh because a lot of our clients are hysterically funny when they get angry, and then we'll put it aside. But get it out. You have to get it out. You are not supposed to be perfect,
I
right?
agree. But the one thing I would add is that if you are writing journals that you know that
Mm.
you need to write dear attorney, so that it's covered by attorney-client privilege and not subject to just discovery.
Smart. Oh
Um,
my gosh, that's right.
yeah,
Yes. Can you talk a little bit about that? Because I was a little shocked during my own discovery where they're like, you need to give all journals,
yep,
calendars. And I was like,
yeah.
what?
Like discovery is very broad as a general rule. Again, I only practice in Texas, but discovery rules exist for a reason. Like you can typically get anything that's reasonably calculated to lead to the discovery of admissible evidence, and that means your Facebook profile, your social media. It means text messages. It means bank accounts, credit card accounts. I mean, discovery is broad. And so if you're writing journals detailing he or she, did this on this day, this on this day, this on this day, and it's a timeline of the abuse, if it's just a journal, you are likely to have to turn it over. But if you're
Wow.
writing it for the purposes of litigation to send to your attorney, it is possibly covered by attorney-client privilege and not subject to
That is
discovery.
gold. Thank you so much. Everybody just start writing Dear Attorney at the top of everything, just in case. Just in
And
case.
right
Why not?
for purposes of litigation, right on there, right every top of every page. If you keep it for the purposes of litigation, for my attorney,
Wow.
attorney's eyes on, attorney's eyes only.
Awesome tip. Never heard that before. Love it. Okay. Any other last minute little tips, Michele?
No, I mean, really, just remember anything you put in writing is Exhibit A in court. So be really careful what you put in writing. I can't tell you. I've got a jury trial that starts on Monday, and we're using communications that go back to 2015, 2016.
Mhm.
And so don't think for a second that even if it's old, it may not come in. Discovery is broad, and what you put in writing can come back to bite you. You know what?
Yep. Yep. Wow. Well, thank you so much. Can you tell people how to find you?
Oh, it's easy to find me. I'm at michelelocke.com. Remember, Michelle's with one L because my mother spelled it the French Canadian way. But I'm also on Instagram at Attorney Michele Locke. But yeah, I'm not difficult to find.
All right. Well, I so appreciate you coming on here and thank you so much. And let's definitely stay in touch.
Yes, absolutely.
All right. Take care.
Bye.
Bye.